Very good evening to participants from India and Singapore, and good morning to our US participants. We are pleased to welcome you to this wonderful session conducted jointly with the American Arbitration Association, ICDR, Asia Case Management Center, with Indo-American Chamber of Commerce to this special edition. Thanks for joining. We would like to introduce you to Mr. Sundaram, who is the Managing Director of South Asia, Lincoln Electric Company India Private Limited, for his opening remarks. So Mr. Sundaram has, in summary, has led manufacturing organizations, including those with overseas operations, for nearly 20 years. He has held key positions, including as the president of Cosmo Films, Global Operations Director, ESAB, prior to that as Managing Director of ESAB India, and President Rani Brake Linings. So Mr. Sundaram has his MBA from IIM Calcutta, and he is a BTech from IIT Madras. With this introduction, I request Mr. Sundaram for his opening remarks and introduction of the other panel members. Over to you, Mr. Sundaram.
Thank you, Sujata. Am I audible? Okay. So, ladies and gentlemen who have, thank you so much for attending today. Welcome to everyone. These are extremely difficult times. We are going through a very, very troubled period. And I appreciate you taking the time off to be here to attend this, in spite of, I know there must be a lot of other pressing issues at hand. So I do appreciate that you're being here. As Indo-American Chamber of Commerce, we will of course aim to make your presence and the time that you're spending here worthwhile. This is something that we would aim to do, that we aim to bring things which are topical and which would add value to you. So this, I think we look at the situation today. We are living in a period of risk. I mean, this is, if we want to avoid risk today, the only thing we can do is sit in our house, sit in our homes and lock ourselves up. Other than that, we are taking real serious risk, not just business risk, but risk with our lives. So I think we are now understanding, it's been brought home to us, exactly what risk means. And what it also means is, and that we are understanding, is that it is not possible to live without risk. We do have to take risk. And the entire focus has to be not about avoiding risk, but about mitigating risk in order to maximize our returns. Now, similarly, if we look at it from a business perspective and not just from our life perspective, I think the COVID has impacted so many other aspects of business that the very meaning of risk and risk mitigation needs to be relooked at. With this in mind, we are bringing to you this session where we are bringing together panelists who have experience in the field of law and in the field of business to understand, to help you understand, and for us to jointly explore what are the risks today and how do we mitigate them. Doing international business, we will not only have business risks, we will have legal risks, we will have all sorts of risks, and we need to understand how we are going to go forward to mitigate them. The session that we are going to have is basically structured in a question and answer manner, because if we are looking at purely at contracts and law, the subject could tend to be pretty dry. So what we have arranged this session to be is a Q&A session, for which we have taken already, some of you have already submitted questions in advance, and we have those questions with us, which we have structured into a kind of format with very broad headings. And these questions will be posed to our panelists, and that is going to be the format. We hope that we will have time at the end to be able to take some additional questions as well. But let's see, it all depends on how much time we have, because we would aim to finish this within 75 minutes. Having said that, so I guess I should not take up too much of time. So with this, I will move into, sorry, that's wrong. Sorry, just excuse me a moment. Yeah, sorry. So I was just saying that, I don't want to take up too much more of your time. So given the fact that this is going to be an exciting session, let me just get on with the introduction of the speakers. So we have Mr. Shrikant Navale, who is an arbitrator and counsel specializing in alternative dispute resolution, having his office in Singapore. He acts as counsel in commercial arbitrations and is a member of the counsel team in investment treaty arbitrations. Shrikant studied law at the National School of India, University, Bangalore, and has an MBA from Cranfield University in the UK. He also holds a graduate certificate in international arbitration from the National University of Singapore. His previous experience has seen him with leading multinational companies and firms such as GE, Ernst & Young, and Arthur Andersen in the fields of international trade, supply chain, tax, transfer, pricing, and customs-related litigation and controversy, with over 25 years of experience both in India and across the wider Asia-Pacific region. During that time, he has been involved in dispute resolution in various forms, including under the procedures available in bilateral tax treaties. We come next to Mr. P. Kaniyappan. Mr. Kaniyappan was appointed Managing Director of WAPCO India Limited in July 2014, and he holds a bachelor's degree in mechanical engineering from the National Institute of Technology, Surathkal, Karnataka, India, and a master's degree in manufacturing systems engineering from the University of Warwick. Mr. Kaniyappan was ranked among the top 100 and best CEOs in 2016 by Business Today, which is the largest circulated business fortnightly magazine in India. He was recognized with Frost & Sullivan's IMEA Lifetime Achievement Award in 2018 for his contribution to the manufacturing sector. These are the two panelists who will be addressing the questions that have been raised so far and who will be talking about risk mitigation in the commercial contracts. Now I come to the person who is going to be moderating this session, our moderator, Ms. Smriti Ramesh. Smriti Ramesh is the director of the Asia Case Management Center, CMC, of the American Arbitration Association, International Center for Dispute Resolution, that is AAA-ICDR. Now, prior to joining the AAA-ICDR, Ms. Smriti was the deputy director of an arbitral institution set up under the auspices of the Asian African Legal Consultative Organization. She was involved in the revision of the Arbitration Act of Malaysia, investor state mediation rules, and a number of other major feathers in her cap. She is the lead contributor for the book Law, Practice and Procedure of Arbitration, and an expert contributor for the book Arbitration in Malaysia, and editor of the Construction Adjudication Reports of Malaysia. Smriti has also practiced in India, dealing with a variety of transactional, domestic, and international arbitration disputes. She is originally a qualified lawyer from India and holds an LLM from the University of California, Berkeley. So with this introduction, I will now hand this over to Smriti. Over to you, Smriti.
Thank you, Mr. Sundaram. Thank you, Sujata, for the introductions. And as Mr. Sundaram said, we are indeed in difficult times, and we're very pleased on behalf of the American Arbitration Association, ICDR, and the IACC to be moderating this panel with a topic that we put together after a lot of conscious thought to see what would be most relevant and topical to participants who are here today from India, from the United States, from Singapore, and from different parts of the world. So before we jump to the topic, I just want to go over some very quick housekeeping rules and the objective of the panel. You are all, as you can see, on mute. However, like Mr. Sundaram said, the concept is to make this panel as interactive as possible. So at a later stage, if you'd like to comment or jump in with an observation or a personal experience of yours, please feel free to use the chat function, or there is a very handy raise hand button that's available on your computer screens. Please feel free to use that, and our team will be monitoring it, and we'll try our best to bring in your comments. Now, we also had the pleasure of receiving a lot of questions from all of you, and we've curated that into 4 very large segments. However, if there is an additional question or context that you'd like to give a question that you've already raised, once again, please jump in to do so. Now, before I go to the topic, I must also point out that our audience today is a fantastic mix of business and lawyers, business professionals and lawyers from across the world. And especially in circumstances like this, I have always been a believer that it's very important to bridge the gap between business and law for truly efficient contract management, or even risk mitigation, as the topic may be. So I'm pretty confident that the takeaways from today's discussion will be useful for both business professionals and lawyers. And with that, I do also want to talk about why we're focusing on India and US. Now, the AAA-ICDR, without taking more than 5 seconds of your time, is one of the oldest arbitral institutions in the world. And our focus when we set up the Singapore Case Management Center, the expanded office 2 years ago after 11 years of presence, was to promote capacity building and case administration and ease for people in Asia. And our focus organically, because we're based in the US, has also been to India, which contributes to being one of our leaders or the top players in terms of numbers. So that's why we're focusing on Indo-US, and our focus in this India series today is on mitigating commercial contracts, but with a specific eye on India and the US. So with that, on our first segment, we're going to be talking about, before jumping into the actual specifics of risk management, I do want to ask our panelists about their thoughts on the changing dynamics of negotiating contracts in the first place. Has the pandemic changed the dynamics entirely, or are we now adopting a back to basics approach? And I think this would be a great way for us to start the discussion before we segue into more technical topics. So perhaps I can get started. Srikanth, would you like to go first, followed by Mr. Kanyapan on this?
Thank you, Smriti. Thank you very much for this opportunity. To those of you who are just joining us, a very warm welcome and greetings to you all. Coming to the question that Smriti just posed, I guess as far as the dynamics of negotiating contracts is concerned, while the basics of contract negotiation and drafting continue to remain, our experience over the last 1 year or so has kind of led us to believe that there are certain aspects of contracts that have commanded a greater scrutiny and attention, as it were. And if I were to kind of list them out, to my mind, these would particularly relate to the clauses relating to performance parameters, termination conditions and consequences. You have the force majeure clauses, and of course, the evergreen warranties and indemnities clauses. These have certainly kind of commanded a lot more scrutiny and attention. But I don't want to leave out what has also developed in importance over the course of the last year, especially, which is dispute resolution and settlement mechanisms. Now, as far as performance parameters are concerned, what we're noticing is that parties are now encouraged to make far greater efforts to kind of agree on alternative methods of performance to the extent that it is possible. And this is with a view to allow for a more meaningful chance, as it were, to the parties to be able to comply with obligations. I think we're all quite, in fact, acutely aware that the supply chains, as far as both material as well as labor, have been disrupted quite dramatically. And therefore, while life must go on, I think expectations also have to be accordingly recalibrated. And in the same vein, to my mind, I think it's in the party's best interest to think through the termination triggers in contracts and the consequences of such termination. The question really is whether the usual trigger should continue to hold, or whether parties should now be thinking of alternatives to termination and provide for a bit more flexibility within the contracts. And we'll come to this during the course of the discussion, I'm sure, in a bit more detail. The one other aspect that I mentioned, which is force majeure clauses, I think have kind of taken a lot more center stage over the course of the last 1 year, and rightly so. Keep in mind that this is an alternative to the concept of frustration of contracts in the common law. And as you're aware, you might be aware that under frustration, there really is no other alternative than to terminate a contract. Force majeure, on the other hand, allows for parties to tailor the circumstances under which these events can actually be triggered, the requirements that are that would be necessary to trigger the force majeure clauses, mitigatory steps, etc., and the consequences of raising such a plea successfully. Now, keep in mind that COVID is no longer an unanticipated event. We are going through second waves and third waves in different parts of the world. Therefore, what might have been applicable to a force majeure event being triggered by COVID over the course of the last 1 year may no longer fly going forward. Companies will now be expected to show that they have taken reasonable steps to avoid, or at least mitigate to some extent, the impact of the disruptions and the restrictions on the contractual performance. So merely relying on the same steps that were taken in the past during the first wave of the pandemic is unlikely to be sufficient. The other aspect that I mentioned was warranties and indemnities. This is an aspect that should be kept which continues to be kept in the center stage when negotiating contracts. Given the uncertainties that have arisen over the past year, it's our experience that parties are understandably keen to limit the extent of the warranties and indemnities that are provided. Parties would seek to limit the liability arising from these breaches, either by way of a materiality filter, which we are familiar with, or a time period limitation for which a particular warranty might apply. This has always been the case, but the attempt to limit the liabilities arising from a breach of warranties is particularly so in current times, with parties attempting to put in broad COVID-related carve-outs or additional disclosures which are extremely broadly worded. And to my mind, these don't particularly necessarily work well, because they actually have to be thought through and have to be specific to be able to hold water. Dispute resolution I touched upon already. It's become particularly important in current times given the number of disputes that are headed for resolution. In a nutshell, COVID has certainly changed the dynamics of how we approach negotiation and drafting of contracts. And I'm sure we'll continue to examine this in the course of this discussion in greater detail.
Thank you, Shrikant. I actually I'm looking forward to discussing this more with you. Before I pass this on to Mr. Kanyapan, Shrikant raised an interesting point about alternatives to termination as well. And we do want to ask you, of course, from a completely different perspective, from the business perspective, have the dynamics changed? But I want to drop in another question that has come from the participants to you, which I think is also quite relevant. Along with the question of changing dynamics, has the standard to measuring risk and consequentially mitigating risk changed because of this pandemic?
Thank you for the opportunity. I would like to wish all the participants the best of safety and health in this difficult time. Yes, the dynamics of negotiation and the drafting of contract has completely changed in the by the COVID-19, because the almost 70-80% of our cost in the business is actually controlled by the various contracts that we have with various stakeholders, maybe suppliers of direct material. If you look at the automotive industry, because most of my experiences in the automotive industry, so I'll be talking from that perspective. Similarly, your pricing also is controlled by your contract with your customers. The COVID has actually, the last so many years, so many decades, we have never faced a situation like this. I've been in the industry for almost 35 years. We had to first face in a quarter that it was almost a washout. There's absolutely no production last year by this time. If you look at the commodity prices increased in the last 1 year, almost 70% in the case of steel, aluminum, maybe 30-40%, copper, and various commodities increased. Prices are increased. The global supply chain actually, went into crisis, particularly on the logistics front. Availability of containers and the vessels, all those things became a problem. We were forced to bring material by premium shipment. At the same time, this Indian supply chain also was completely strained because the bringing people to work and every front, it's a completely new normal. So in order to succeed in that difficult, volatile environment, absolutely we need to look at the possibility of renegotiating. Not necessarily in all cases, changing the contract, but then there is a possibility to revisit, because in the case of the commodity prices, last 10 years it was very much, more or less it is stable. There was no need for us to completely look at that as in a need to review. But then, ever since COVID came, we were not able to even follow the normal cycle of six months time frame to review the prices. We had almost every 2 months we had to go to the customers. Same case with the suppliers, they approach the customers. It was a completely a new normal, that's the time. Actually, normally the businesses don't look at the contract in a big way normally, but then this is the first time all of us are really looking at every element of the contract and see, how to really manage this crisis, how to protect, how to mitigate the business. So many times we need to reset the contract with the customers with a clear indexing on the commodities. On the same case with the suppliers. So it's completely changed the rules of the game. So the dynamics of negotiation is completely different now. The suppliers, it used to be a customer power. They used to dictate what should be the terms, but it is last 6 months or 1 year, if you look at it, it's opposite. Today, the success of the company depends on the supply chain and how we manage the supply chain. That decides the way we succeed in the business. So it's more of a supplier power. That's the current situation. So in this new normal, obviously renegotiating the contract or revisiting the contract, this is all very, very important topics.
Thank you, Mr. Kaniyappan. I think points about the collapse of the supply chain, etc., have truly indeed altered the scope of the contract. I must say it's not just businesses that are taking a keener look at contracts. Lawyers are taking a keener look at businesses as well, because some of the issues that you brought up is not something that at least I'm sure Shrikant can correct me if I'm wrong, is not something that's on the top of a mind when a lawyer draws up a contract or even the risk mitigation clauses. With that introduction, I think we've set the stage very well for exploring a little bit on issues of risk mitigation in drafting. And like I said, one of the key topics that we will be exploring during the course of this session will be the perceived gap between a legal and a business interest, and how does one bridge the gap. So with that in mind, I'm going to pose to both of you this very interesting question that we got from one of the participants. In the present sense, and let's assume all questions come from a present scenario circumstance, what would be the most 3 critical items, issues, or clauses in a commercial contract as of today? And how would you approach it, either from a drafting perspective or from, say, a business CEO across the table negotiating it? I'm happy for either Mr. Srikanth or Mr. Kanyapan to go first, so I'll leave that to you.
So maybe I'll go.
Sure.
No, today the challenge we face is to for example, the time schedules, meeting the delivery precision. This is completely today not in our hands. Particularly if you are, let's say, dealing with semiconductor crisis or any global, you are a part of a global supply chain, because we are into allocation mode. When you're in allocation mode, you don't have the buying power. The supplier has the buying power. Whereas in the earlier contracts, there are contracts which says that if you stop a customer line, you have to pay penalties. There's a lot of risk associated with stopping a customer line. So my first interest would be to limit all this, risk that is associated with the deliveries, which actually contributed by factors that is beyond my control. The second is the performance guarantees and the bonds associated with such performances. Again, for the same reason, my performance, if it is not limited to or it's not in my control, it's a global phenomenon, something by the act of God. So that is my first one. And then also in some cases, waiver of consequential damages, or the claims by my end customers' claims. Such topics we are not in a position to today accept. Also, of course, limitation of the liabilities. We would like to set, even in certain cases that there are liabilities, we would like to limit the liabilities to certain, probably a percentage of the business, etc. These are something that I would like to look at as a priority topics at these times, where the whole things are not in our control itself.
Smriti, if I may,
please do, Mr. Sundaram. Yeah.
So just one thing I'd like to add to what Mr. Kanyapan had said is that yes, he is focused on delivery, but I think one thing which has been left out of commercial contracts and which is not really focused on commercial contracts and which I find now is getting much more of a focus is price. Now, for example, customers are asking us, we've got customers who want us to quote for delivery in September. Right now, the current steel situation is that prices on the steel prices are going completely haywire. Right, so we've seen that recently China has withdrawn its export rebate of 13% on steel, which is going to cause the global steel prices to go up sharply. So these are the kind of things which have a huge impact on pricing. Now, as Mr. Kanyapan mentioned, steel prices from last year to this year have changed by 70% to 80%. My calculation was somewhere in the middle of last year, it's closer to 80%, but it's between 70 and 80%. Now, that's not a joke. Over 1 year in past, it's changed by 7 or 8%. Now it's changed by 70 to 80%. Now, that's something which is, so when we are looking at commercial contracts, I think now price has to come very much into the equation, because we are looking at possibly for a period of time rampant inflation. With we've seen at least we have seen something like 90% increases in copper prices. So this is something which has to be built into contracts as well, because controlling the prices, everybody has got some commodities going into his products, and without the control over that, there's got to be some bar which is set. There's got to be some withdrawal clause, something which is said, which says that if the price of steel goes beyond X or something like that, then all bets are off. I think that is a very important aspect which I would consider apart from delivery, which Mr. Kanyapan has already mentioned.
Thank you, Mr. Sundaram. I think the point about withdrawal clause is very interesting. And I, for one, am very curious to see what Srikanth has to say for that. Srikanth, your own 3 critical line items, and perhaps if you can add a line or 2 on the points that both Mr. Kanyapan and Mr. Sundaram raised.
I will try. Thank you, Smriti. So as far as the way I see it, to add to the points that have already been made, one critical aspect of negotiating a contract to me would be the due diligence process itself. That actually, to my mind, provides the financial and technical capability information about the counterparty you're doing business with. How equipped is that party actually to carry out contracts or the obligations that he's undertaking to do so in the current times, and how best is that party placed to make good for the certain disruptions that are bound to be there in the current environment. Now, there may be significant imperatives for pushing ahead with a particular deal or a commercial arrangement, but despite everything that precedes the negotiations, to me, what sets the stage for the successful negotiations to follow and the contract to be drafted would be very, very largely dependent on the outcome of that due diligence process, because that then feeds into the kind of representations and warranties that are being sought and the guarantees that are being sought from that party. The point was made about limitations being sought to be drawn on the kinds of representations and warranties, and I've already mentioned the materiality limits that come in and the time limits that people seek to put in. But during current times, it's likely that a number of these risks are only likely to surface belatedly. And so parties try to have these very, very broad pandemic carve-outs, as it were, in extremely broadly couched language. Now, whether that actually flies or not is something that needs to be tested in courts. I would have my own reservations about how successful they would be. But from a business legal perspective, one way of mitigating this is for parties to also explore the concept of warranty insurance. And this has been a concept which has been around for a while, but is beginning to take a lot more center stage now, and people are warming to that idea. This could be either a buyer side insurance, which allows for a buyer to more quickly proceed against inaccuracies in warranties without actually going through the entire lengthy proceedings of dispute resolution and leaving that to the insurance companies. Or it could be seller side warranty, seller side insurances, which
Srikanth, we lost you there for a second.
Hi, are you able to hear me?
Yeah, we lost you at seller side insurance though. Now, yes, but we lost you at seller side insurance.
My apologies. Are you able to hear me?
Yes, now you're back on, and we lost you at seller side insurance. So if you can pick up from there.
Yes, so I was saying that the other option is for a party to insist on the counterparty seller to also pick up insurance, which allows for the seller to safeguard against his or her own losses. So these are ways in which some of the issues that were surfaced could potentially be mitigated. And there was also the other point that you asked for my comment on, Smriti, but which I'm blanking on at this point. Could you please repeat that? I'm sorry.
I think it was there were 2 points. One was a point that was raised to waiver or consequential damages. And the other was the clause that Mr. Sundaram was mentioning in terms of having a cutoff when they're negotiating for price, etc.
Indeed, I mean, those are terms that we are seeing already being negotiated into contracts. Like I said, these are limitations which are being sought to be drawn in on a time-bound basis, which say that the prices that will prevail is as on a particular date, and you can't really have an open-ended arrangement as far as pricing is concerned. So most certainly, this is something that can be built into a contract, and we are seeing these limitations being built in more often than not.
Thank you, Srikanth. I think there's a lot of food for thought from what all 3 speakers said. If I can follow up to a point that you made about due diligences and ask Mr. Kanyapan, for businesses, or say for contracts that are negotiated now at the commencement of the business relationship, what are the decision methodologies or markers that you use to analyze risk, say now in a crisis situation such as this? Has that changed, or can you shed some light on that?
No, when we develop a new business with anyone, there's a standard practices. For example, first we need to tell them the statement of requirement, clearly explaining what you want, what you are actually looking for, and then of course there's a site visit, understand, do due diligence, understand the customers, suppliers capabilities, their technology capabilities, their financial capabilities, robustness of their financial system, and their own supply chain, and their ability to meet your requirements. So essentially, you send your experts, study the company in details, whether their safety standards, quality standards, manufacturing system, everything will meet your expectations. And then you obviously have a checklist, and then rate them as whether they qualify as a complete straight away approved, or you need to work with them to get to the approval standard, or you reject them. So these are the things we do, and then make sure that there is a common alignment built, meaning the shared vision or shared goal in this case, to try to work out a model in which this is a win-win type of arrangement. And then you, of course, you have to handhold them and help them to really rise to the level that you need in case they are not able to do themselves. This is a framework. How it changes now is, of course, you cannot physically nowadays able to audit. Today the audit itself, there are multiple levels. So you can today do the virtual audit. Companies have developed system to audit virtually. People sitting in Europe can actually audit the manufacturing plants in India. And of course, the audit involves both document audit and physical audit. So all these things are done today virtually. This is the only change. But otherwise, we don't deviate from this process, because it's a very robust process that is already established to ensure that you have the right supplier for this, for whatever product or service that we want to secure.
Thank you, Mr. Kaniappan. I think with that, I do want to move on to the next segment, but I have a couple of questions to wrap up this segment on drafting these contracts. So in terms of in terms of risk mitigation, given that that's the topic that we're focusing on today, we have already looked at some of these areas, but I do want to ask both of you if you perceive any areas or gaps or risk areas that haven't been addressed or that should specifically be codified into the contract. Has this been, this could be, of course, also arising from practical experience. If you've had situations which you've addressed, we'd be very keen to hear it. But I do want to ask about these codified risk areas. And Shrikant, just when you're addressing this, if you could also throw some light on how much has the need to focus on dispute resolution arisen, especially with cash flow issues. And I'm not just talking about courts and arbitration. I'm just talking about finding ways to resolve dispute conflicts or cash flow issues. And on second thought, I think Mr. Kaniappan, your thoughts on focus on dispute resolution would be great too. So Shrikant, if we can start off with you.
Thanks, Smriti. I mean, as far as terms that don't particularly get codified or don't find their place in contracts, or if they do, how are these terms particularly dealt with? Apart from the usual unfair or unconscionable terms in a contract, which we are familiar with, which kind of get codified against in some form or the other, and there is sufficient body of case law to guide us on how and when these may be invoked. The tendency really is to leave the actual terms of the contracts themselves to the respective parties' commercial bargaining power. And therefore, it's not really for the law to step in at every invitation and try and codify it, or in fact, try and fill the gaps that may be in the contract when the parties themselves could have applied their mind to that particular situation. But that said, in situations as remarkable as the one that we are currently facing, we have seen courts actually stepping in. And a good example of that is in the case of Halliburton versus Vedanta, which was a case that was decided last year by the Delhi High Court, where the court actually found that the government ordered lockdown was a valid force majeure event, even where the contract was not being entirely clear about this. So the contract hadn't even contemplated this. But nevertheless, the court felt that the government ordered lockdown was a significant force majeure event, and that the interests of justice would be served to take the lockdown measures into consideration and rule that a certain bank guarantee which was about to be invoked should be injuncted against from being invoked. So the court actually stepped in and said that they would extend the time period for performance by a period of a week or 10 days after the lockdown was lifted. So you see, the contract, the parties themselves could potentially have provided for this in the contract, but given where they were and given where we are currently, it's quite impossible to do that. And that is where we rely on agencies and the adjudicating agencies like the courts to step in and do the needful in such areas. You also asked me a second question as regards dispute resolution and how much the focus on dispute resolution has particularly changed during this pandemic. I mean, this is a favorite topic, and this is something that's talked about quite a lot amongst us practitioners. The dispute resolution clauses are typically referred to as these midnight clauses, simply on account of the fact that they don't get very much time during the negotiation process itself. It's often one of the last clauses that gets to be discussed and incorporated. And it usually draws from a previous contract on a cut and paste basis without particularly adjusting for current facts in the context. So we see a number of differently drafted dispute resolution clauses, which actually pose different kinds of challenges at the time when they need to be invoked. But this is improving, and parties are now paying a lot more attention simply because COVID has enhanced the importance of these dispute resolution clauses, with parties no longer willing to go through with the entire expensive litigation or arbitration process. Now, you mentioned cash flow. You're really seeing that as a large driver of how people are approaching dispute resolution. So although there might actually be an arbitration which people need to resort to, parties are saying, all right, let's initiate that arbitration because that is really where we need to go. But fact of the matter is that the record number of arbitrations that are being initiated, I don't see them going all the way to the end. They're really being initiated so that at some stage, people will come back to the negotiating table, and companies that are looking to manage their cash flow times are willing to look for settlement options. And these settlement options are really a fallout of the arbitrations that might have been initiated, and from a tactical perspective at that. So really, it's all about trying to get parties into the settlement discussions, even though the dispute resolution clause provides for arbitration as a means of dispute resolution. So I hope that kind of addresses the question that you were asking.
Absolutely, Shrikant. Mr. Kanyapan, do you have your thoughts to add, please?
As far as risk management is concerned, I would say from a business perspective, this is an area we are only at a surface level, scratching the surface. It needs a lot of focus because nowadays risk everywhere. But then my personal belief is that the businesses don't spend time on that aspect much. Particularly if you're a smaller company, because larger companies, they actually engage legal counsel, lawyers to handle that aspect. Also, if there's a board, there's a risk management committee, etc. But if you go to mid-level or smaller companies, I don't think there's a big framework available with them to handle to assess the risk and mitigate the risk. There's a huge opportunity existing. That's in my view, from a business perspective. Coming to the other question of dispute resolution, yes, whenever there's a dispute, normally we try to resolve within the internal escalation framework, meaning if it is from a supplier and customer, then at a higher level, they try to discuss and then try to solve the problem. If it is not possible, then there is an alternate resolution framework of mediation or conciliation. If all these things doesn't work, then you go for an arbitration. This is a typical framework, but largely, in a spirit of partnership, we try to resolve many of the issues as an internal escalation framework.
Thank you, Mr. Kanyapan. I do have a follow-up question for both of you, but I want to circle back for just 1 second on the point that you made in terms of smaller organizations not having the framework, and also Shrikant speaking about the midnight clause, especially when it comes to dispute resolution. From an institution's perspective, one of the things that we noticed is that the AAA-ICDR came up with something, an automated tool called the clause builder, nearly a decade ago, where parties could just log in and pick their own clause, which seemed to be a quicker but painless alternative to having a midnight clause. In fact, we'll probably just drop by the link for everyone to take a look at. Although it came about 10 years ago, this saw so much traction during this present crisis time, because it really ends up being a reference point for people to understand what these codified risks and systems are. So I thought it might just be nice for all of you to have this resource as well, and we put that here at the link. But to circle back finally to the dispute resolution question is what Mr. Kanyapan said about mediation. Now, this is a buzzword that's happening not just in India, not just in America, but owing to a lot of issues. In fact, I personally think the pandemic has served as a catalyst for a lot of people to come back to the table to see mediation. So Shrikant, there were a couple of questions that we received in terms of not just mediation, but also recently the Singapore Convention. For the benefit of the non-lawyers, Singapore Convention is a tool that was recently passed. India is a signatory but has not ratified, which was meant to be a formal mechanism to enforce a mediated settlement agreement. So what is the status, or how much of an effect will the Singapore Convention have on Indian parties who are choosing to mediate, whether amongst themselves or whether with their counterparts in the US?
Yeah, I mean, mediation was there even before the Singapore Mediation Convention happened. And certainly what the Singapore Convention has done is to raise the profile of mediation as a viable alternative to some of the other alternative forms of dispute resolution. I think the idea behind the SMC really was to allow for mediated settlements to be given the same status as, for instance, an arbitral award, in that the signatories to the convention would recognize these mediated settlements and allow for enforcement in the countries where they needed to be enforced, without the need for resorting to lengthy legal procedures, such as one might find in the case of enforcement of a regular contract. So the idea is that it allows for it to be enforced much like an arbitral award is enforced as a decree. Now, the problem you mentioned, though, Smriti, is a very, very, very valid and key point, which is that although we currently have about 50
Shrikant, I'm afraid technology is playing villain again. We've lost you. Can you hear us? Is there a technical issue? Should we circle back?
Haven't yet heard from the policymakers on when.
Shrikant, I'm sorry, we completely lost you for about 30 seconds there.
I'm so sorry that the network is a little spotty. I hope you can hear me now.
Yes, we can hear you now. Yes. But we've lost you again. Well, in the interest of time, why don't I give you, Shrikant, are you back on? I was just about to move on. Yeah. Yes.
I'm so sorry. I really apologize for the spotty network.
No problem. This was actually, I think we're still trying to figure out what's happening. Shrikant, while you fix it, I think it's the right time for me to ask Mr. Kaniappan a very obvious question. Mr. Kaniappan, one of the questions that we received was, how do parties or contracting companies use technology to mitigate risk in these times? And I think it's a very topical question, particularly given that these things happen with technology repeatedly. So what has been your experience thus far? And Shrikant, I will circle back to you. I'm just giving you some time to sort out the technical, any technical issues that you may have. Mr. Kaniappan?
Yeah, today the digital technologies actually are very much, useful to mitigate risk. In, of course, I am from a manufacturing background. So, say, for example, safety or a quality type of risk today, we can very well mitigate using the digital technologies. It is absolutely possible to create a production system which in which there won't be any incident or accident, which was not possible earlier, because so much of sensors and you can actually create a zero incident environment. Also, the same case for quality. Quality, for somebody who wants to export from India, the challenge used to be the kind of quality standard that you are able to deliver. Again, because the model used to be, the production system used to rely on the alertness of the people. But then today, various technologies are available with which you will be able to really produce parts without any defect from the system. Even if some reason it is produced within the product one station, you can stop it going to the next station. Also, so similarly, the warranty or all those things can be really controlled. Product recall issues can be addressed through traceability systems. Today, the barcode based traceability systems are available to virtually eliminate the risk in all these areas. So the digital tools have very much become an enabler or a risk mitigating mechanism for areas in safety, quality, warranty, product recall, such topics. Like that, it depends on the case-by-case basis, but all these things are today available.
So if I may come in here, Smriti.
Yes, Mr. Sundaram.
Okay, so one of the things I think we'll be looking at as we go forward is Internet of Things. Particularly industrial Internet of Things, one of the biggest things that's happening. Now, obviously, one of the things that makes Internet of Things so valuable is that the fact that the cost of acquiring data has practically, it's crashed to such an extent that acquiring data is so cheap that it's not something which is even worth sort of talking about. So the real hurdle to getting Internet of Things is how quickly you can get a system in place, how quickly you can evaluate your factory, how you can get a system in place. So that will then give you a lot of benefits as far as Internet of Things is concerned. But how is this connected to contracts? Now, what some OEMs are doing is they are having Internet of Things at their supplier end, and they are monitoring what is happening at their supplier end. So I know OEMs who actually have Internet IoT at their customers end, at their vendors end, and they're keeping track of how much production has actually come out, which is related to them. They are obviously, so some of the vendors block issues related to costs and so on and so forth for obvious reasons. But output and quality are two things which can easily be determined, and those are things which the OEMs can keep track of. So as we go forward, we'll see a lot more digitalization where IoT is involved, and which then ensures a high level of transparency between the customer and the supplier, which then reduces the burden on the contract as such, because of the high level of information exchange. So that, I guess, is one of the things that I see in technology going forward, which could mitigate the dependence on contracts rather than changing the nature of contracts.
That's a very interesting point, Mr. Sundaram, and we see this playing out just as an add-on. I see that Shrikant's back, but before I pass on to him, we see this play out actually in the dispute resolution process as well. Initially, we thought this would this whole pandemic and the crisis would create like a huge stoppage of the various processes that we go through, including arbitration and dispute resolution. But as an institution, once we provided that bare level of support for virtual hearings, including providing people with the platform, etc. We've seen that many parties, particularly Asian parties, say in India, Korea, and other places, have been quick to jump on and have managed, in fact, the whole expert process, dispute resolution process online. And the common popular opinion seems to be that there's a lot of cost saving going on by using these virtual tools and technology tools, so that it could actually become maybe not mainstream, but it will become an integral part of not just the contract drafting process, but also the dispute resolution process. Shrikant, if you're back on, I just want to ask if you have any quick questions on the use of comments, on the use of technology, because I also am conscious of the time, so I would like to move on to the next segment once I hear from you on this.
Certainly, and apologies for the spotty network. I will stay off video, so hopefully you can hear me better. I think to add to the points that have been made as far as use of technology is concerned to mitigate risks, I think one area is where companies engage forensics and technology practitioners who typically use an array of sophisticated tools and resources to track down assets and reconstruct financial records. And this is typically for the purposes of recovery proceedings. Now, as I mentioned, these tools are currently used at a later stage, either during the dispute resolution process or at the stage of enforcement of the awards. However, I actually see the possibility of these tools being used at a much more advanced stage in the contract negotiation process. This is essentially to arrive at a better profile of the counterparty. As I said, if you have a forensics and technology team looking at the capabilities of the counterparty as well as the financial track record of the counterparty, it actually then becomes an adjunct to that whole due diligence process, which I emphasized at the beginning of this discussion. As far as the point about countries adopting it, I agree with you. If there is a developing country which will seek to adopt such technologies, India will probably be at the forefront of it. Even if it may not be widespread for a while, it is certainly one of the developments which I see catching on over a period of time.
Thank you, Shrikant. Thank you, Mr. Kaniappan and Sundaram. Given the paucity of time, I am going to move on to our last broad segment, which was ideally a lot of the questions that came in dealt with practical considerations. We've looked at negotiating, we've looked at drafting contracts, and now is the time to look at practical consideration when a contract or a commercial transaction goes south. And like we've repeatedly spoken about during the course of this has happened a lot. Like Mr. Kaniappan mentioned, in the first quarter, there was a complete stoppage of and a collapse of supply chains, which obviously put into motion a lot of commercial transactions and contracts going south or terminating, etc. So one of the questions when looking at practical considerations comes from our participant asking about how this risk allocation, when there is an issue, works when one party has no or minimum negotiating power. Mr. Kaniappan, I think this would be a question that we're very keen to hear your thoughts on.
Normally, the risk should be allocated to the party that creates or generates that risk. But the best part of managing this is to create a trust in the system. Basically, there has to be a trust between the parties, and it's not a question of who has the negotiating power, but essentially build a trust in the system that there's a common goal or common objective in the whole thing. That will, my view is, that should be the basis for resolving this aspect.
Thank you. Shrikant, I think adding to what Mr. Kaniyappan said about creating a system, etc., when it comes to identifying or practical consideration, what are the roles of legal or third party in this stage? Because generally in most business transactions, you will see that lawyers come into play when the transaction goes south. And this again comes back to this whole lacuna that we talk about, that there is a huge divide between the business and contract, the lawyers that needs to be bridged. So do you have any comments on the role of third party, or what are some of the questions that businesses should be asking the lawyers at this stage when there's a dispute?
I mean, I'd start by saying that there are two kinds of lawyers. You have the third-party legal counsel and you have the in-house legal counsel themselves. And each have a certain role to play in this whole process. The fact is that an in-house legal counsel has a very, very significant role simply because the buck stops with him or her. Third-party legal counsel are brought in on account of the breadth of experience which potentially an in-house legal counsel may not have in dealing with a certain set of circumstances. Therefore, it's really up to the in-house counsel to understand how a certain decision, say for instance on financing, on regulations, on competition laws, antitrust, as it may be, how they actually play out in a given scenario which is being faced by that particular company. So the fact of the matter is that given the breadth of experience that the external legal counsel have, they have quick access to the industry practice and the norms. They have a certain database from which they can draw, an extensive database from which they can actually draw, terms and conditions that might need to be incorporated. And really, it's for the in-house legal counsel to come in and understand why a certain term is being suggested, for what purpose. Say, for instance, in an M&A deal, for instance, you have an in-house, you have a third-party counsel which would suggest a side letter to capture certain terms and conditions of the deal, as opposed to actually it being on the main contract itself. Now, why does this happen? The third-party legal counsel may understand very, very quickly that there are confidentiality issues or special terms and conditions that need to be included, which doesn't need to be transparent to the other parties who may be involved in the main contract. But the in-house legal counsel's role is to try and question that and understand whether that really needs to be on a side letter or push for it to be included on the main contract. So these are kinds of the dynamics that you see playing out between an in-house legal counsel and a third-party legal counsel. But the fact of the matter is that the reason why you have a third-party legal counsel out there is to plug in the gaps in the experience and understanding which the industry exposure provides to the third-party legal counsel, and not necessarily to the in-house legal.
Thank you, Shrikant. I think that sort of cements the role, or rather sums up very accurately what the third-party counsel does. Before we explore further, I want to go back to another question that just came in terms of practical consideration when the transaction goes south. And this one is to Mr. Kaniyappan. Mr. Kaniyappan, how does one, from your experience, determine performance of contract when that's being the issue discussed? And the question specifically is, can this be changed after the contract's already signed? Has this happened in your experience, meaning the definition of the performance of contract be changed subsequently?
Yeah, maybe it's a very, very, very good question. Actually, the contract management or a performance of the contract can be used as an instrument to improve the, unlocking the value from the whole contract, from whole, between the parties. If you really rightly use the contract, because certain the contract should not be looked at merely in a transactional type of approach, but can that be used as an instrument that improves the efficiency of the performance of the parties? If it is a supplier, can you really make sure that you put certain clauses which says a continuous improvement, in the system? Because there is a McKinsey article which says you can unlock almost 9% of the by value by properly managing the contract or performance of the contract correctly. Meaning there is definitely a possibility to incorporate such clauses if again, if both the parties come together and work together to try to unlock the value that can arise out of this contract itself. But in reality, what we do is generally we don't spend time on these things. No, from a leadership or from a business side, normally this is left to the legal counsel or the at that level or the somebody at the lower level to decide the terms of the contract, and it is approved by the council. But then that stays wherever it is. Nobody reviews. But then there's a very good opportunity to review, use that as I said, a tool of control or a tool of improvement, and to unlock value from the whole system, provided we both the parties come together and then try to set certain improvement framework in the contract itself. I hope I made my point clear.
Yes, Mr. Kanyapan, I think that's a very valid observation. I think it's something that we will all keep an eye on in the coming days. I'm very conscious that we're short of time, so I do want to have this opportunity maybe to take a question or two in the end. So maybe I can move on to my last question before we address any audience questions, which would be to, and I know this is a very tall ask, but perhaps I will anyway pose it to you in the hope that this will be of benefit. One of the questions were the top trends or best practice that you anticipate in with your expertise in the coming days, particularly in risk mitigation. So if I can ask all three of you to speak about, and Mr. Sundaram, if you are around, it'll be great to have you weigh in this as well. What would you anticipate are the best practices or the top three trends that you will see, particularly with risk mitigation and contracts in the coming next few, I mean, it's hard to quantify a time period, but as long as this crisis is on and forward thereafter. Shrikant, would you like to start off?
Sure. As far as trends go, I think the top trend that I see developing would be third-party funding coming to the fore, especially during the arbitration process or even the post-arbitration process, to monetize the award, so as to kind of meet the cash flow needs that, as we have discussed, has become top of the agenda for most businesses. I think the second point is something which I touched upon, which is I actually think indemnity insurance is going to take a center stage in the whole process, with more and more parties willing to consider it and more insurance companies actually willing to offer it. And finally, the other point that I made earlier in the discussion, which is the role of extensive due diligence, not just to assess the technical capabilities, but also to facilitate the financial risk assessment in the event of a breach of the warranties and the indemnities that are being provided. I actually think this is going to be something that will gain a lot more attention. So I'll leave it at that.
Thanks, Shrikant. Yeah, thank you, Shrikant. I think those are very interesting trends, and I fully agree. I also just want to add one other point that one of our participants, if I'm getting the name right, Mr. Tong Wang, has added. He says procedures like the expedited international arbitration that the ICDR has, which means there are no complex oral hearings and parties just resolve it by written submissions only within 60 days. These sort of innovative mechanisms will also probably take the forefront, as what will be the need of the hour is cost sensitive and other options for parties. So yes, thank you for that observation, and I think we fully agree. Moving on to a more business perspective, Mr. Kanyapan, would you like to predict your top three trends or best practice suggestions?
Yeah, my first one is in the area of drafting the contract itself. Today, as I said, this is done at a very lower level, maybe at a functional level. Some executives decide, and then sequentially it goes to the legal counsel. So legal counsel takes care of the legal aspects. But the right way to be done is to create a multifunctional domain experts into that along with the legal counsel. Jointly, they have to draft the contract to understand how that can be effectively used as a from taking care of both parties win-win type of approach. That will change the the approach itself, and I'm sure that will be owned by various stakeholders in the system, and the contract itself will have a life on a real time that will be reviewed. The second aspect, as I said, is how to unlock value from the contract itself by setting certain improvement clauses, continuous improvement clauses type of things as a part of the contract, so that both the party works towards improvement, maybe cost reduction, maybe improvement of quality or a warranty, anything. So this is second. Third, of course, use of the digital tools is something that is like also Mr. Sundaram said. It also will change the the way we look at risk and how it can be mitigated. Also, that's my third suggestion.
Thank you, Mr. Kaniappan. Mr. Sundaraman, would you like to add to that?
Well, I'm not very good at predictions, but one thing is clear, is that yeah, Mr. Kaniappan broadly touched on it, but I think what's happening today is at a top management level, we do not take contracts very seriously. We assume that contracts are like a very broad framework. It's not like in Netherlands. I mean, if you look at two Dutch people having a contract, it's X, it's by the letter, right? But if you look at India, very broadly, it's like, theek hai, chalta hai kind of thing. It's we understand this, and we understand that when situations happen, we talk to each other, and in a situation of trust and so on. But I think one trend which is going to happen is that people are going to be looking at clauses and other things a lot more closely to understand what exactly is meant by force majeure, what exactly is meant by by warranty clauses, and clauses by which they are bound, which could happen any time, and which currently are not really seen by them seriously. So I think there's going to be a lot more top management involvement in understanding in sort of, let me say, approving contracts. Today, somebody, yeah, I think Mr. Kaniappan mentioned it, some XYZ at the lower level just takes it forward and gets it done. And later on, when you look at it and you say that the customers, hey, there's somebody saying that you got this clause in your contract and you're bound by it, and you suddenly wake up and say, oh, is that so? So that's something which perhaps could change going forward. And the top managements and the legal counsel would look at it very closely before approving any contract.
Thank you.
That's one different trend I see.
Thank you, Mr. Sundaram. I think the point that seems to be the common thread here is that there's going to be a lot more cohesion between the business aspects and the legal aspects. And I think this is one sort of harmony that will be most welcome. What we will also do, just for the benefit of all the participants, is probably when we send out the recording link, we will add in our existing resources that are available for not just clause building, but also we have a couple of documents on what are some of these clauses that you should pay attention to. I see in the chat box that there's a lot of discussion on boilerplates, etc., which because of the paucity of time, we're not going to further expand on, but they're all extremely excellent observations, and we will try to keep this conversation going and not just let this be a one-off. Once again, since we were very particular about keeping time, especially during these difficult times, I think we will call this session to an end with just a couple of quick remarks from Sujata and the IACC. But before I hand it over to her, I do want to thank both Shrikant and Mr. Kaniappan, as well as Mr. Sundaram, for this absolutely enlightening session. I had a fantastic time and I have learned so much today, and I'm sure this is the same for all our participants as well. So thank you to all three of you, as well as all our participants, for being so patient, for being so generous with your questions, which resulted in this excellent discussion. We will, if there are any unanswered questions, we will be sure to circle back, try to get our speakers' input on it, and make sure we email it to you. So thank you on behalf of all of us. And Sujata from the IACC would like to just conclude today's session. So I'm going to hand this over to her. Sujata, all yours.
Fine with thanks, Shmiti. I think it is all. Thank you so much for your wonderful moderation and engaging with everyone. It's a pleasure for IACC to associate with AAA-ICDR for this session. It's a good beginning, I feel. Probably we look forward to working more with you. And of course, sincere thanks to the panelists, which you have already done. Mr. Sundaram also happened to be the chairman for the Indo-American Chamber of Commerce Tamil Nadu chapter. And we have Mr. Karniyappan, who is also in our leadership committee at the Tamil Nadu committee as well. Thanks to Mr. Srikanth. It was a wonderful session and great to have you. Just for the benefit of audience, Indo-American Chamber of Commerce is based in India. It's started in 1968, and we are here with 11 offices across India, facilitating trade between India and the United States of America. So I've shared my email ID as well. So if any of you would like to reach out to us, please feel free to write to us. With these few words, thanks again, Shmiti. Thanks to everyone, or to all the participants for joining. Thank you.
Thank you.
Thank you.
Good evening and good morning to the rest of you in the US.
Thank you all.